Good morning, everybody, and welcome to the latest of Shepherd and Wedderburn's Property Dispute Resolution Group seminars. My name is Colin Archibald. I'm a partner in the Commercial Disputes team at Shepherd and Wedderburn, and I head up the Property Dispute Resolution Group. So it's a very warm welcome to all of you for this morning's seminar entitled Managing Property Portfolios, Landlord and Tenant Rights and Remedies. And in a few minutes, I'll hand over to, first of all, Daniel Bain, and then Serena Weir to look at various aspects of today's topic. I should also flag that whilst there is a Scottish focus to what we're talking about this morning, we do have some plans to look at the position in England, where there is a good amount to say a little bit later in the year. So watch this space. But Dan will look at a range of issues in relation to landlord and tenant rights and remedies, and then we'll hand over to Serena, who will look at a range of issues with a particular focus on insolvency aspects. So I'll pass over to Dan in a couple of minutes. Inevitably, with these matters, there is always just a little bit of housekeeping, even if a bit less than if we were doing this in person. If we were doing it in person, we would say there are no fire alarms planned, but coincidentally, out of our control, we do actually have a test in the office at around 11:15 this morning. So we'll see if we can engineer it so that the in-office speakers are not speaking around 10:45. But if there is, then we will just work through it, and you may have a short few seconds of muting whilst the beep goes off. But just to mention that. Another couple of things just to say before we kick off. First of all, whilst this is the third, I think, of the sessions that we've run online over the last year and more, we are beginning to think about a return to in-person sessions, and you will receive a poll in the course of the next few minutes, all going well, just asking for views on returning to in-person sessions and what your preference is. So we'd be very interested to hear your views. The second thing to mention is that you should be able to see the Q&A box, and we will be delighted to receive any questions about topics arising in the course of this morning's session, and we'll pick as many of these up at the end as we can, and don't be shy, because of course they'll all be anonymized, so please ask away. And the final thing to mention is that just as we would if we were running this session in person, we will be sending out the recording and the slides to this morning's attendees, and indeed everybody who has signed up for this morning's session. So that is something that will follow over the next few days. So with one final reminder again to please let us have any questions that you would like us to try and answer at the end of the session. Without further ado, I'll pass over to Dan, who will get us started. Thanks very much.
Thanks, Colin. So yeah, as Colin mentioned, I'm going to look at really landlord-tenant rights and remedies, and in particular, some of the sort of key issues to bear in mind when considering how to go about enforcing tenant obligations under a commercial lease. As many of you will know, during the course of the pandemic, at various periods during the pandemic, a landlord's ability to enforce commercial lease obligations was curtailed. The parties' legal rights and obligations were not affected, but it's more about how a landlord could go about enforcing obligation, in particular, as we'll come on to see, a landlord's ability to recover possession when a tenant was in breach was restricted. At times during the pandemic, particularly early on, the civil courts were only dealing with urgent business, which meant in practice that a landlord couldn't really resort to court action to try to recover rent arrears, for example. And also at times during the most stringent lockdowns, sheriff officers, for example, due to social distancing, were not carrying out summary diligence, which is obviously one of the options available to our landlords we'll come on to see. So at times there were restrictions in place. So whilst the legal rights and obligations were not affected, a landlord's ability to enforce obligations, to recover rent arrears, was affected. Those restrictions have now eased. We're obviously, hopefully no more lockdowns. So we're kind of as you were in terms of lease enforcement, but of course we're in a very sort of different economic position, and no doubt there will be tenants out there who have been significantly affected by the restrictions that were in place during the pandemic, and so it's all the more important for parties to be very much aware of what their legal rights and obligations are, and what what to do in circumstances where a tenant is not able to comply with those obligations. So that's, we're going to be looking at that very much with that in mind. Many of you will also be aware that in England legislation has been introduced to introduce an arbitration scheme for determining disputes between commercial landlords and tenants where there are rent arrears. That legislation only applies in England. It doesn't apply in Scotland. I don't intend to say much about that, Colin, or anything about that. Colin has mentioned it is intended that we will look at the English position in a later webinar. So, it was just worth mentioning that that legislation does only apply in England. So in terms of what I'm going to be looking at, as I say, really it's a question of how to deal with a failure to comply with lease terms, particularly a tenant's monetary obligations. I'm going to be looking at the sort of key things to bear in mind with a view to proactively managing defaults or potential defaults, how to go about resolving defaults when they arise by agreement, and if agreement can be reached, what are the options for enforcing the tenant's obligations. In terms of managing defaults, really, it's I think knowledge and communication are the key things. There are a range of options available, and a judgment call has to be made on what action to take. So it's vital that that a landlord and indeed the tenant in a situation where there is a default has all of the knowledge that they need, and that there is clear and effective communication between the parties in terms of trying to resolve that. The more you know, the better the judgment call is going to be. So, it's a question of looking at all of the options and deciding which is the best one. What you've done in the past might not necessarily be the best thing to do now, particularly in the sort of circumstances that we're in at the moment, post-pandemic, and in particular the position that many landlords and tenants are in at the moment. So it's a question also of thinking about, well, what are your objectives? Is it just simply a question of purely recovering the arrears, or actually are there wider considerations? Are there other objectives at play? We'll come on to look at that. I think it's also important to kind of act fast, take action, to try to resolve the problem before it becomes worse. So I mentioned knowledge is key. Well, what is it that you need to know? Well, clearly from a legal perspective, it's vital that you know the lease, that you know precisely what the lease obligations are, not just the lease itself, but of course any variations to the lease that have been agreed, any rent review memoranda, any back letters that may be in place. It's vital that both parties know what the relevant terms are. And if you're in any doubt about what they are or how they are to be interpreted, then it's important that you take legal advice on that. It's also important to check, obviously, is there a rent deposit agreement or guarantee in place? Because that's going to have a bearing on what action you might take. Also, is the lease registered for enforcement? As we'll come on to see, there are options available which are only available if the lease is registered. So that's a key consideration. Are there any forthcoming break options that either party might want to exercise? That may well be a consideration. And also, when does the lease expire? From a landlord's perspective, it's really important that you know the tenant, the business that they operate, their financial position, the issues that they're facing, or the issues facing the sector that they operate in. Again, all the more important, I think, kind of as we're kind of coming out of the pandemic, or hopefully coming out of the pandemic. Is there a history of defaults or financial difficulties? Again, that's going to have a bearing on the judgment call that you're going to be making. It's also important to have as much information as you can about their assets, because some of the steps that you might want to take, as we'll come on to see, really in terms of whether they're worth taking or not, will depend on the tenant's asset position. It's also important to know the issues, as in the current issue that has led to the current default or the current dispute. How has that arisen? Is this just a one-off situation, or actually is there do you think that there are going to be ongoing difficulties here? And actually, is there a dispute? It may just simply be that there isn't actually a dispute about the rights and obligations. It may just be an inability to pay. But in some circumstances, there is actually a genuine dispute between the parties. And if that's the case, again, that's going to have a bearing on how you go about trying to resolve that. So it's important to understand that if there is something that actually is in dispute between the parties. So in terms of what your objectives are, from a landlord's perspective, is it just a question of enforcing the obligation? In some circumstances, it will be. You just simply want to recover the arrears and move on. But there may be wider considerations at play here because of the wider circumstances. So it may be that actually agreeing something with the tenant might be more beneficial. So, for example, how important is it that good relations are maintained between commercial landlord and tenant here? Again, it comes back to some of the things that I just mentioned. How long has the lease got to go? Is there a risk here that there are going to be ongoing difficulties, or that actually the tenant might run into serious difficulties, and you might ultimately end up with a vacant unit if you just go straight to enforcement action? So I think it's important to consider whether actually reaching some sort of agreement with the tenant might be more beneficial than going straight to taking enforcement action. One option that is available, which we'll come on to look at in a little bit more detail, is the option of ending the lease and recovering possession of the property in the case of a default. And that of course, is the irritancy remedy that's available to landlords. Again, there are considerations that come into play there. What are the prospects for securing a replacement tenant when you end up having a vacant unit? It's also important to keep in mind that if you do take that step of ending the lease, the rates liability is going to revert back to the landlord. So that might not be something that you want to do. So again, it's important to just think about just precisely what your objectives are in looking to try to resolve the situation that has arisen. So I mentioned that in some circumstances, agreeing a solution might be the most beneficial thing to do. That's the thing that might actually, it might ultimately resolve the situation in a way that means it doesn't get worse, that the tenant doesn't end up getting into a worse position, which might not be in the long term beneficial for the landlord. It also preserves landlord-tenant relations, which may be important, particularly if, for example, this is a tenant where, as a landlord, you may have this tenant across a number of different properties, across the country. So, again, that may be a consideration here. Again, communication is absolutely key between the parties in terms of understanding just precisely what the issues are and how the situation has arisen. In terms of reaching an agreement, the sort of possible solutions might be, a payment plan for payment of the arrears, or maybe a temporary variation to the payment terms of the lease. possibly assignation, if the tenant is struggling, if they want to assign or sublet, that may be a solution in the particular circumstances. Or it may be that actually, the tenant wants to end the lease, and from a landlord's perspective, if there's a good prospect of reletting the property, then ultimately a renunciation of the lease, an agreed termination of the lease, may be something for the parties to keep in mind. Some of these things are things that we saw, after the economic crash, sort of around about 2008 onwards. We saw some of these things. So, many of you will be familiar with some of these issues and the sort of solutions that were put in place between commercial landlords and tenants. So none of this is particularly novel, but I think these are the sorts of things that we may be seeing again in current economic circumstances. A key thing, though, is that if an agreed solution is reached, it's vital that that is documented in writing, so that going forward, the parties are absolutely clear on what has been agreed. Problems can arise if that isn't done, and I think it's something that it's important for the parties to take advice on. If an agreed solution isn't reached, well, there are a range of enforcement options that are open to a landlord. I've already mentioned irritancy, and I'll come on to look at that. But it's not so much a means of directly enforcing the obligation in question, although actually it can have that effect. So that's not mentioned on the slide here, but I will come on to look at that. But in terms of options for directly enforcing the obligation, there are really four main things. And the first one, the one that we would generally always recommend that's taken is, as a first step, is a demand letter. And sometimes, a demand letter from a solicitor is sometimes sufficient to actually solve the problem. If it isn't, there are other steps that can take, and a statutory demand can be issued, which could lead to steps being taken to put the tenant into insolvency, and Serena's going to be looking at that in her talk. That again was something that was restricted during the pandemic, so wasn't really something that was open to landlords. But again, Serena will be talking more about the sort of options that are available and issues that can arise in an insolvency situation. Summary diligence. We'll look at that's there are a range of options that are available if the lease is registered for enforcement purposes. There are a range of options that are available to a landlord to seek to recover arrears, and there is also the option of raising a court action for payment, or if it's a breach of a non-monetary obligation, for enforcement of that obligation. So just looking at summary diligence, which is one of the key things really that's available to a landlord. It is relatively quick and inexpensive, but as I've mentioned, it's only available if the relevant lease documents are registered. So the appropriate register really in Scotland is it's called the Books of Council and Session. So this is where your lease gets registered and you get back an extract, and it's kind of warranted for enforcement purposes. In certain circumstances, even though you've got a registered lease, you might need to go and get a court warrant authorising summary diligence. That's necessary if, for example, the landlord named in the lease is a previous landlord. If you've purchased the property and you become the landlord by virtue of that. So in those circumstances, it may be necessary to actually go to court. Again, that's relatively quick process. And once you've got that warrant, it's not necessary to do that again. The important thing to bear in mind about summary diligence is that it can only be used for sums that are specified in the lease documents, or where there's a clear mechanism in terms of the lease documents for determining the sum due. The upshot of that is that it's normally only available for rent arrears. It's difficult with service charge, for example, where the amount changes from time to time depending on what services are provided. Unless there's for example, a formula in the lease that determines what service charge is due or a clear mechanism that means that can be determined just simply on the basis of the lease documents, that's not going to be something that you can look to recover by way of summary diligence. The main options as far as summary diligence are concerned is charge for payment. That's usually the first option that's taken. It's a formal demand. It's served by sheriff officers demanding payment of the outstanding sum within 14 days. And that's a necessary precursor to certain further steps that can be taken. For example, attachment, which is the last bullet point there. So that's usually the first step. It's relatively inexpensive, and again, because there are potentially serious consequences for a tenant, and potentially insolvency consequences if you don't comply with a charge for payment. Quite often that does result in a resolution. Arrestment is another option whereby a sheriff officer essentially serves an arrestment on a third party who is holding money for the tenant. So the most common example of that is a bank account. So the arrestment would be served on the tenant's bank if you happen to know which bank the tenant is with, and that will essentially freeze funds in the bank account, which in due course would be released to meet the debt. It's only effective, of course, if there is money in the bank account, but it's a step that is sometimes worth taking, particularly if you know what bank the tenant banks with. If you don't, you can serve arrestments on a number of banks. At the end of the day, if they don't happen to bank there, or there are no funds in the account, then you would generally find that out. The reason for that is that there's an obligation on the third party to disclose if anything is caught by the arrestment. So it's something that's quite often worth trying. Inhibition, maybe depending on the circumstances, an option. This is it's a means by which essentially if an inhibition is served, the tenant, if the tenant happens to own any land or buildings, they would be prevented from selling or granting a charge over the land and buildings for the period of time that the inhibition remains in place. So it's not something that kind of will directly result in recovery of the funds that are available, but if the tenant does own land or buildings, it can be useful. It can be useful in terms of putting pressure on them, and it lasts for a period of 5 years and can then be renewed after that. So that's something. It is something that's worth bearing in mind, depending on the tenant's asset position. And then there's attachment and money attachment. Attachment is a form of diligence whereby sheriff officers will essentially go along and inventorize movable assets owned by a tenant, which are then essentially frozen and can, in due course, through the process, be sold to go towards the debt. It's not necessarily a swift process. It can be a little bit cumbersome, but again, if you know that the tenant owns a lot of valuable movable assets, it's definitely something that's worth bearing in mind. It is one, though, that requires a charge for payment to be served in the first instance. So you need to serve the charge for payment with the 14 days having expired, with payment not being made. Then you can move into carrying out attachment. Money attachment is a form of attachment that specifically applies to cash. So if the tenant has a business where there's a lot of cash on the premises, then that's one where the sheriff officers can go in and effectively freeze cash. Maybe becoming less useful nowadays, particularly post-pandemic, where most businesses actually are operating with in terms of with cashless transactions. It's possibly less useful than it used to be. In terms of raising a court action, your options there are an action in the sheriff court or the court of session. Which court will depend on the amount of the arrears. In most instances, it's going to be the sheriff court, but depending on the value of the arrears, you might want to raise it in the court of session. I think in most instances it's going to be the sheriff court. In most instances, there isn't going to be really a dispute about whether or not the debt is due. It's just going to be a question of looking to enforce it. So you would generally do that in the court of in the sheriff court. If the debt is of a value that means that it can be raised in the court session, or if there's if there's a dispute about it, a dispute about the parties' rights and obligations, then that may be more appropriate. But I think circumstances in which you would raise it in the court session are going to be pretty rare. So irritancy, I mentioned, is not a sort of a means of enforcing the obligation as such, but it can have that effect. So as many of you know, irritancy is the means by which a landlord can take steps to terminate the lease and recover possession of the property in circumstances where a tenant is in breach. And threatening to do that can, in some instances, actually result in a resolution. It can result in the tenant complying with the relevant obligations. So it is very much an option that's available to landlords as a means of trying to resolve disputes and enforce obligations. There needs to be an irritancy clause in the lease, but almost all commercial leases do have that, and it will generally provide for termination in the case of, firstly, a monetary breach, secondly, a non-monetary breach, and thirdly, in the case of insolvency. The option is subject to statutory protections, which are there to ensure that the remedy is exercised fairly, and we'll come on to look at that. So the clause in question will provide for the basis for irritancy. Say, it will almost always provide for irritancy in the case of non-payment of rent for a particular period of time, for example, 21 days, but also for breach of any other obligation of the tenant, for example, a failure to comply with repairing obligations. And it will also commonly provide, give the landlord the ability to irritate the lease in an insolvency situation. Other common things that you might see in an irritancy clause are that irritancy is without prejudice to the landlord's rights in relation to any breach before the irritancy. So, rights and obligations are preserved in terms of any breach that has occurred. There may be specific provision for a pre-irritancy notice to be served, although, as I'm going to come on to mention in a moment, that's required in terms of legislation anyway. And in the case of insolvency, the irritancy clause might provide for a period for assignation of the lease by an insolvency practitioner. So if that was something that would be something that I think it would be important to take advice on if that is there. I mentioned that there are statutory protections in place. These are in the Law Reform Miscellaneous Provisions Scotland Act 1985. In the case of a monetary breach, the landlord is required to serve a pre-irritancy notice requiring the tenant to pay the outstanding sum within a specified period of time, and the notice must state that if the tenant doesn't comply, the lease may be terminated. The specified period must be at least 14 days and must be longer than that if the irritancy clause provides for a longer period. Now, I mentioned earlier on that the landlord's ability to irritate a lease was curtailed during the pandemic, and the way that was done was that coronavirus legislation extended that 14-day period to 14 weeks. So it was still possible for a landlord to seek to terminate a lease by way of irritancy, but you had to give not less than 14 weeks notice in terms of your pre-irritancy notice. But that restriction was lifted in April and is no longer in place. So we're back to the 14 days. In relation to non-monetary breaches or insolvency, what the legislation provides is that the lease cannot be terminated if, in all the circumstances of the case, a fair and reasonable landlord would not terminate. And I'll come on to talk about that and again in a moment. In terms of the pre-irritancy notice, I mentioned the notice must specify what's to be paid and the date by which it's to be paid, and it must state that the lease may be terminated if the tenant does not comply. The period of time specified, it's a period of 14 days immediately following service, longer if the irritancy clause provides for that. The method of service is also something that's important to bear in mind. In terms of the legislation, it must be served by recorded delivery. And if the lease requires another method of service, that method must be used too. And it's also important to bear in mind that the irritancy clause might require service of the pre-irritancy notice on a security holder, for example, a standard security or floating charge holder. There are pitfalls here. There are a number of things that must be complied with for the pre-irritancy notice to be valid, and there are pitfalls there. So it is something that we would always recommend that is done by solicitors to seek to avoid falling into any of those pitfalls. If payment is made in accordance with the pre-irritancy notice, then the lease cannot be terminated. But if payment isn't made in the specified period of time, then further notice must be served to terminate the lease. I mentioned earlier on the fair and reasonable landlord test, as it's referred to in relation to non-monetary breaches. What that generally means is that whilst there isn't that same requirement to serve a pre-irritancy notice, one of the factors there in determining whether a fair and reasonable landlord would terminate is whether the tenant has been given a reasonable opportunity to remedy the breach. So in practice, probably will want to serve a pre-irritancy notice requiring them to remedy whatever the breach happens to be and giving them a reasonable period of time to do that. So that's something that's important to bear in mind in relation to non-monetary breaches. If the breach is not remedied, you've served your pre-irritancy notice, it hasn't been remedied, then there's a further notice to be served to terminate the lease. That should refer back to the pre-irritancy notice, record that the tenant has failed to comply with the requirement in the pre-irritancy notice, and state that the lease is terminated with effect from the date of the notice of irritancy. It should also make clear that termination is without prejudice to the landlord's rights in relation to any pre-irritancy breach. I've mentioned the fair and reasonable landlord test. I mean, really there, what legislation provides is that all the circumstances must be taken into account. And as I've said, the tenant must be given a reasonable opportunity to remedy. In terms of applying that test, there is some case law on it, not a lot, but what is clear is that it's looking at it from the perspective of a hypothetical landlord, but that hypothetical landlord is generally assumed to be in the same position as the actual landlord and to have the same state of knowledge, although they might be expected to have made inquiries that the actual landlord didn't make. All the circumstances of the case might go beyond the landlord and tenant relationship to include, for example, the circumstances of an insolvency practitioner, and there is some case law on that. Involving receivership. It's not simply a sort of a balance of hardship. A fair and reasonable landlord, the case law is quite clear on this, a fair and reasonable landlord can eventually lose patience, and a landlord doesn't have to disregard their own commercial interests. But to be fair and reasonable, they might have to moderate the extent to which their commercial interests are pursued. So the tenant's position is relevant, and the other thing to bear in mind is that the time at which the test applies is the point in time when the landlord terminates the lease. So anything that happens after that point in time isn't relevant in determining whether the test is met. I'll just mention briefly here, if the tenant is in administration, then it isn't possible to exercise the right of irritancy without the consent of the administrator or the sanction of the court. And in considering whether to sanction irritancy, a court will consider all the facts and circumstances and balance the interests of the landlord against the interests of the creditors of the tenant as a whole. So that is just something that's important to bear in mind if the tenant is in that sort of situation. And the slide there sort of mentions a few of the considerations that might come into play in that scenario. Once the lease has been terminated by virtue of irritancy, then it is terminated along with any sublease that may happen to be in place, the parties are generally freed from their obligations, and the tenant has to remove from the premises. If the tenant doesn't, then there are further steps that would need to be taken to forcibly remove them. The landlord generally remains entitled to any outstanding sums that are due as at the date of termination. And of course, there might also be a dilapidations claim that can be pursued. So that's a sort of fairly quick canter through the various options that are available there. As Colin mentioned, please do, if you have any questions, please do put them in the Q&A box, and we can answer some questions at the end. But for now, I will hand over to Serena.
Thanks, Dan. So my name is Serena Weir. I'm a senior associate in the Commercial Disputes Finance and Insolvency Litigation team at Shepherd and Wedderburn. And today I'm going to look at the situation where a tenant becomes insolvent. And since March 2020, landlords and those representing them will obviously be acutely aware of the measures that have been introduced by the government to minimise the scale of tenants entering into insolvency. That said, as matters stand, I consider that we're likely to be heading towards recession, so it's even more important than ever that landlords are aware of what they can do when their tenant enters into insolvency. So what we're going to cover today, firstly, we're going to look to set the scene regarding the current economy and legal positions and recent cases, looking at the various insolvency regimes, how creditors' claims rank, what happens when a tenant enters into an insolvency process, submitting claims and how to value claims, removing from the premises, and hypothec. So looking back at the landscape, probably about 15 years ago, the most likely outcome for a landlord if a tenant went into an insolvency process was either that the insolvency practitioner and the landlord would agree a surrender of the lease and the landlord would find a new tenant, or the insolvency practitioner would simply sell the business and the lease would be assigned to the purchaser. Now, that situation has been different, certainly for a few years now, but I think that's even been more pronounced since March 2020. And the short point is that there are far fewer purchasers of insolvent businesses in the market, and landlords are less likely to have a new tenant waiting in the wings. So looking at the various insolvency regimes, I think often the terminology can be quite confusing, and that's not helped by inaccurate reporting in the press. But what the regimes have in common is that an insolvency practitioner, an IP, is appointed to manage the affairs, except in the case of a CVA where the IP has a much more limited role, and then to distribute those assets in accordance with a statutory priority. The differences between the procedures tend to be as a result of the different aims. So from a landlord's point of view, most complex issues can come up when the insolvent entity wishes to continue trading. So that's most common in administration, as the administrator will want to sell the business as a going concern where possible. Now, the regimes which are set out in the slide are all Scottish, but broadly the same in England. A trustee in sequestration or under protected trust deed is unlikely to trade on. The aim in that situation is to wind down, and the same applies in liquidation. In administration, the aim is to rescue the company as a going concern or achieve a better result than liquidation. So often that's achieved by selling the business as a going concern. Receivership isn't a formal process, it's a way in which a floating charge holder is able to enforce their security. And CVAs are increasingly common, although the numbers of them have been quite depressed over the past few years. Those types of procedures are quite unique in that the directors stay in control of the company, with the IP only administering the CVA itself. Next, go to look at creditor claims and ranking, and what I've set out in the slide is the order in which creditors will be paid from an insolvency process. That's often referred to as the waterfall. It's important to note there's obviously some important case law on expenses, which is very relevant for landlords, which we'll come on to look at in a moment. It's also important to note the reinstatement of a crowding status as a preferential creditor from the 1st of December 2020 for PAYE, NIC, CIS and student loan repayments. Also important to note the status of the floating charge creditor, that's obviously subject to the prescribed part. And then we have unsecured creditors, and that's the most common position for landlords. albeit it's important to note the hypothec, which we'll come on to look at in a few minutes. So firstly, let's look at rent as an administration expense. The law previously wasn't clear on what rent was as in terms of an administration expense, and it tended to be dealt with by arrangement with the landlord, whereby rent for the trading period would be paid. And then we had the case of Goldacre against Nortel in 2010. And in that case, Nortel's administrators used a small part of the premises, and the landlord sought full repayment of the rent as an expense, as the premises were being used for the purpose of the administration. The administrator said that even if the rent was an expense, it was only appropriate for a proportion of the rent to be paid for the space and the time that was actually being used. And in that case, the landlord was successful. So if the premises were being used for the purposes of the administration, then all of the rent falling due must be paid as an expense. Then we had the case of Luminar, which made clear that only rent falling due could be considered as an expense of the administration, so not arrears. And in that case decided that where a quarter's rent payable in advance fell due before entry into administration, none of it was payable as an administration expense, even as the administrators retained possession of the premises for the purposes of the administration. So the effect of Goldacre and Luminar was pretty unsatisfactory for landlords who could face a substantial period without rent being paid. And the timing of the appointments became really important in administrations, because if the rental obligations particularly were significant, and this was something that landlords had absolutely no control over. So there was a risk also for administrators, because any occupation on a subsequent rent payment date would mean having to pay the rent for the whole of that period. And there'd be no rent reimbursement if the administrators didn't occupy the premises for all of that period. So then in 2014, we had the Bain case, in which the Court of Appeal ruled that rent payable in advance would now be treated as an administration expense for the whole period of occupation of the premises by the administrators for the benefits of the administration. And in that case, Bain's administrators sold the assets of the group, and that included a number of the stores which continued to trade. And the question for the court was whether they had to pay £3 million of unpaid rent that had fallen due for those stores. So prior to the ruling, the appointment of the Bain's administrators the day after the rent payment date had fallen due would allow the administrators a rent-free period until the next quarter day. But the administrators relied upon Goldacre and Luminar and did not pay the rent. So the landlord sued the administrators for the unpaid rent, and the Court of Appeal decided unanimously that the administrators were liable to pay the unpaid rent. So essentially, the Bain case ruling overturned the previous position, because the court held that rent should be treated as if it were a debt incurred by the administrator, and therefore as an expense of the administration. So it's going to accrue on a daily basis, irrespective of the date in which the rent failed to be paid. So the court disregarded the common law and the statutory rules that apportionment does not apply to rents payable in advance, and relied instead upon equitable principles. So this result was seen as a complete victory for landlords, and the court held that a strategically timed appointment of administrators would no longer provide a rent-free period. So it was a return to the pay-as-you-go regime which existed prior to Goldacre and Luminar. In Scotland, the leading case in rents as an admin expense is Cheshire West and Chester Borough Council against Springfield Retail Limited, and that case concerned liability for rent which fell due post-appointment. So the administrators did not personally use the premises for the purposes of the administration, but they did grant a 6-month licence to the purchaser of the business. The terms of the licence required the purchaser to pay rent directly to the landlord, but contained no direct covenant with the landlord. So no rent was paid and the lease was not assigned. The Outer House of the Court of Session held that the administrators liable for the rent for the whole period in question, and that court's ruling was consistent with the Goldacre and Luminar decisions. Really, we're going to have to wait to see an application to the Scottish courts on similar facts before it becomes clear whether the Scottish courts will adopt the Bain approach. And that is not inevitable, because the Scottish rules on admin expenses are similar to their English counterparts, but they're not identical. It's also relevant that the equitable principles that the Court of Appeal relied upon in that case are not applicable in Scotland. So the advice to landlords remains to contact the IP at the outset, to ensure that the IP is aware of what is expected. And obviously bear in mind the moratorium which Dan mentioned in his presentation, because that can be lifted in certain circumstances. So next we're going to look at the effect of insolvency on a lease. It's fair to say it's a complex area of the law. The lease does not automatically terminate on insolvency, except in the scenario which I've set out on the slide. And there's a variety of different effects depending on the lease, the insolvency process, and the type of entity. The significance of the different outcomes for the lease and what the landlord can claim for. Rates, the general rule is that the basis for determining liability to rates is based on occupation rather than ownership. And that means that where a property has a tenant in place, it's the tenant that's liable to pay the rates rather than the landlord. Dan's obviously covered in his presentation termination of the lease on the grounds of irritancy, so I'm going to look at some of the other grounds. Agreement is obviously a basis on which the lease can be terminated, or exercising a break option available to the tenant in terms of the lease. And parties could also look to agree a repudiation, which ends the lease. For example, if the tenant notifies the landlord that they don't intend to perform the lease obligation, and the landlord acknowledges that and accepts the keys back. In that situation, the landlord can claim for the rent up to the date of termination, and then for any damages post-termination. Disclaiming onerous property is obviously a point to bear in mind. There's the decision of the Inner House of the Court of Session in Scottish Coal, which held that Scottish liquidators don't have a power to abandon onerous property. So that case was an application by the liquidators of Scottish Coal, who sought directions on whether a liquidator who was appointed to a Scottish company could abandon onerous property in Scotland and disclaim an onerous statutory licence. And at first instance, Lord Hodge confirmed that both the heritable property, which was owned by the company and forming part of the liquidation assets, and the licences which were incidental to that property were able to be disclaimed. And that would have achieved the same practical result as in England, where the liquidator has the express statutory power to disclaim onerous property. But the Lord Ordinary's decision was reversed on appeal, and the Court of Appeal held that the liquidators of Scottish Coal do not have a power to abandon heritable property in which the company has a real and registered right. The court examined the ways in which ownership of the real right in heritable property could be terminated under Scots law, and concluded that the present circumstances did not fit into any of those recognised categories. In certain situations, the lease might continue. The landlord might want the lease to continue, but obviously care needs to be taken in terms of what constitutes acceptance of repudiation of the lease. So the landlord can act inconsistently, for example, refusing to accept repudiation, but also taking keys back to the property and starting to market. The IP might also want the lease to continue. The IP might want to realise value by assigning the lease, may need the lease as part of a sale of the overall business, or the IP might also need to occupy the premises in the short term if it's going to continue trading for a short period of time, for example, to complete valuable contracts. You also might be in a situation where there's a question about adoption of the lease. IPs, as a rule, are keen not to adopt the lease for fear of personal liability, and again the courts are very slow to infer that. Instead, what the IP will look to do is preserve it as an agent. If the landlord wants to terminate by way of irritation, then of course there's the moratorium and the fair and reasonable test, which Dan referred to in his presentation, that needs to be borne in mind. And in terms of a claim in insolvency can be made up to the adoption, and then it's personal liability against the IP or an admin expense if the business continues to trade. If the business isn't trading, then it's a claim up to the insolvency, and then future rent to be discounted. Looking now at claims in the insolvency, we'd always recommend that landlords look to submit a claim. Quite obviously, that's to preserve the right in relation to distribution of any funds which are realised. But it's important to bear in mind that the IP may not adjudicate on claims for some time. It's also important to submit a claim so that the landlord can participate in the process, so that they can vote, perhaps get an accreditors committee, requisition meetings, exercise some sort of influence. Obviously, whether that is worthwhile depends on the circumstances. But the onus is very much on the creditor to lodge the claim. Landlord and other creditors should receive a claim form from the IP's office. But obviously, if that doesn't arrive, then you should be proactive in following up by getting a copy of that and submitting it. The creditor can also contact the IP to discuss intentions, and certainly solicitors are very often used to open those channels of communication and to assist. It's really important to open up that line of communication with the IP early on to establish if the IP intends to continue to trade, if they're looking at marketing the lease, if they have a purchaser lined up. Although if you're in a situation where where there has been a pre-pack, then all of that might have been agreed before the landlord receives any substantive communication from the IP. But also to discuss proposals in terms of payment of rent during any trading periods and submitting a claim or asserting hypothec rights. Damages are also available in some circumstances. What I've set out on the slide is the steps taken to quantify that sort of damages claim. And we also want to look at removal from the subjects by the IP. So any obligation regarding the state to return the property obviously still exists, but any claim for damages would rank as an unsecured claim in the insolvency. And the IP is only personally liable for negligence, and that's very hard to prove depending on what evidence you have of that. Finally, just looking to touch on hypothec. Now, obviously, this operates like a security that ranks in insolvency, so there's nothing that a landlord can do prior to that. Landlord's hypothec is a form of real security over the movable property, which would include stock, which belongs to the tenant and is situated within the let premises at the point of insolvency. And the effect of hypothec is that those movable items or their net realisable value are to be applied to the satisfaction of the landlord's claim for all unpaid rent equally with those claims of other secured creditors and in preference to the claims of ordinary creditors, but it doesn't apply to future rent. So the hypothec may have a significant effect on the level of recovery by a landlord for his outstanding arrears of rent, and the hypothec arises automatically by operation of law. So the landlord doesn't have to commence court proceedings to enforce their rights on this ground. But it is advisable for a landlord to intimate this in writing to the IP just as soon as reasonably practical that they intend to claim or enforce the rights arising by virtue of hypothec. And at the very least, we'd suggest that reference to the hypothec should be included in any response to any claim form which has been issued by the IP, which will typically request details of any security held by the landlord. So when intimating the hypothec to the IP, it's always advisable also to request that the IP produce details of the inventory of stock, which was taken upon their appointment, together with any valuation of the goods owned by the tenant within the premises. And it goes without saying that a landlord really does have to be proactive in this, looking to contact the IP immediately on insolvency to assert their right. Don't assume that the IP will treat you like a secured creditor. And obviously, it's helpful if you have as much information as possible about what is on the premises, because this issue comes into sharpest focus when the IP is looking to sell assets. But obviously, they shouldn't do so without the landlord's consent. So that's some leverage that you can use in those discussions. So thank you very much for your attention. I'm really looking forward to hearing from you about the results of our poll for the next PDRG seminar, and I'll pass back to Colin for any questions.
Thank you very much, Serena, and thank you, Dan, as well. If there are any final questions, please take a moment to send them in, but there's one or two I wanted to pick up on. First of all, a very easy question as to whether the slides will be available. And for any of you that missed the introduction, just to confirm that the slides and a recording of this morning's session will be made available afterwards for anybody who missed any parts of the presentation. So a nice easy one to kick me off. The second one that cropped up picks up on something that Serena had mentioned, that sort of general observation about a lack of tenants. And the question was whether there was much recent evidence of the use of irritancy to recover commercial premises. I have got a couple of experiences of that, but I don't know, Serena, Dan, if you have anything you particularly wanted to observe on that front before I add my thoughts.
My experience is that, due to the lack of available kind of tenants waiting in the wings, landlords are trying to kind of think a bit more rationally about the options that are available to them. So if going down the irritancy route is either, stymied by the tenant, the landlord's trying to kind of pivot to look at the other enforcement methods that are available to them. So lots of tenants have obviously been in receipt of government funds, so is serving a bank arrestment to try and recover some of those funds an option? And I've had a few landlord clients who have had good success with that.
Mm-hmm. Dan, was there anything that you wanted to feed into the discussion?
No, I mean, my experience has kind of been broadly similar, that in most instances, I think it's other options that are that are more valuable, I think, in the current circumstances. That's not to say that there aren't instances where a landlord comes to the conclusion that actually terminating the lease and recovering the unit is what they want to do, but that has to be the right option in the particular circumstances. And as Serena said, I think the key question there is, is there are there tenants waiting in the wings who can come in place of the existing tenant?
Yeah, no, and I think that has to be absolutely right. And the one observation I wanted to make was actually a particular client we were acting for recently. One of the team had a small handful of instructions to irritate leases within a short period of time. And that was quite striking, quite surprising, because it happens so relatively rarely these days. When I started doing this work over 20 years ago, I would routinely be instructed to try and secure an irritancy on the grounds of failure of a monetary breach of the lease. But really, since the credit crunch of the late noughties, irritancy has been a rarely used remedy for all the reasons that we've touched on. So whilst I wasn't dealing with those particular instructions, and so wasn't having the conversations with the clients about precisely why they were going down this route, as I understood it, that was essentially a situation where there were replacement tenants lined up. I know that is that was a portfolio where there was a reasonable amount of churn and turnover of tenants. So I think it's reasonable to infer that there would be replacements lined up so that you don't end up with a vacant unit, with a unit for which you have responsibility for business rates and so forth. And it comes back to the point that Dan made about making your decisions by reference to the particular circumstances. So maybe there will be an increase if you have the right circumstances. But if, as Serena's touched on, economic headwinds are only going to strengthen, then I would be surprised if we see regular significant use of irritancy. The next question we had is, does hypothec cover all previously accrued arrears, or is it limited? Probably one for you, Serena.
Yes, so limited to the arrears that have fallen due in the 12 months prior to insolvency, and it's arrears, not future rent.
Another probably quite quick question. How often do you use the Court of Session for the recovery of rent arrears? And I'll maybe just pick that up because I can think of, but my answer is I've never done it. And these days, I mean, when I started practicing, the threshold, the claims above £5,000 could be raised in the Court of Session. It's now over £100,000. I suspect the circumstances in which a landlord will have allowed £100,000 worth of arrears to accrue will be relatively limited. And so for that reason, aside from any others, it tends not to happen. Where the Court of Session proceedings have been raised will typically be larger service charge disputes where there's not only a significant issue or sort of significant monetary sum in issue, but also you might have a more complex factual or lease interpretation point that informs whether or not there is a liability. So it is a question of whether there is a liability at all, and not, as Dan touched on in his session, a circumstance where there's little debate as to whether the rent's due. It's just a question of whether it's been paid or not. And I think that's exhausted the questions from the panel, but I had one last one. Serena, if I could, because it just came out of your discussion of Luminar and Game and Nortel, and whether it's interesting that there has been so little authority in Scotland and no authority since the 2014 decision of the Court of Appeal in England. And what I wondered was whether in practice, even if there isn't a Scottish authority on the point, practitioners tend to make their decisions deal with these matters on the assumption that the English position is likely to be applied by the Scottish courts too, even if we don't have a Scottish Court of Session case to that effect.
I think that's correct. And I think we'd be kind of correct in taking that approach. It's obviously going to be a kind of brave landlord or insolvency practitioner who's looking to incur the cost and the time of putting that decision to the Scottish courts. So on the basis of that, I think they'd be quite happy just to assume that the Scottish courts will arrive at the same sort of reasoning as has been found in England.
Great, thank you very much. I think, as I say, that's all the questions from the audience. So thank you very much for the questions that you've sent in. Thank you for signing up and logging in this morning. One final reminder, if you haven't done it already, to complete our poll. Actually, one very last one. Is there an online small claims process in Scotland? Now, Serena, I actually don't know whether you can do it online, so I wondered whether you happen to know the answer to that.
Yes, so Simple Procedure is an online portal which has recently kind of been launched by the Scottish Court Service. So that is the kind of Scottish equivalent for small claims.
Great, thank you. So just to complete what I was saying in relation to the poll, if you get a chance to complete it, that would be much appreciated. The slides will follow. And all that remains for me to do is to thank Serena and Dan for their presentations this morning. Thank you all for coming along, and we'll see you in a few months' time. Thanks very much.
Thank you.